Thank you for visiting our site. This is Angela Jones, Registered Unlawful Detainer Assistant here, and today we're going to be talking about 3-day notice to perform a covenant or quit. So this is more of a detailed process. It's a two-step process. When tenants are not complying with the terms of the rental agreement, that are for non-monetary violations. So we're talking, it says no dogs, yet you have a dog, right? It says maintain the landscaping, but it's overgrown or whatever the case may be. It says no smoking, but yet you're smoking on the premises. Unauthorized occupants, so on and so forth. Please keep in mind that before choosing this option, you should be reviewing the agreement very carefully and be sure to include every non-monetary violation that in fact the tenants are in violation of. And so you would reference page number, paragraph number as to how they are in violation of that covenant of the agreement. And so on our intake form, it's very straightforward. And then if we have any follow-up questions, we would then just email you and ask you with regard to clarifying whatever non-monetary violations that in fact they are in breach of. So once the 3-day notice to perform a covenant or quit is served, they have 3 business days to correct the violations. If any of those violations are not corrected within 3 business days, it is always highly encouraged for the landlord to in fact get some kind of physical evidence such as photos, ideally that, they are in fact still in violation of the 3-day notice to perform a covenant or quit, and they have not corrected the violation. Once that expires and the landlord has obtained some kind of evidence that in fact they are still in violation, then we would proceed with preparing and serving a 3-day notice to quit. And that would state, what violation that they have not cured, and move forward with preparing and serving the 3-day notice to quit. And then they would have 3 business days to vacate the premises. If they do not vacate the premises after 3 business days, we would then proceed with filing an unlawful detainer action in court. And just keep in mind the burden of proof is always on the landlord that in fact they are in violation, and that you have not, extended the period of time in which they need to cure or ever, agreed that, whatever violations that you're stating that they are in violation of, that's, okay. Just make sure that you stand strong on the notice and proceed if in fact they are still in violation of any covenants of the written agreement. You cannot serve this notice if you don't have a written agreement. So please make sure that in fact you do have a written agreement and that they are truly violating the written agreement. Stay tuned for more ways of how you can terminate tenancy, and I look forward to working with you.